I want to welcome everybody to creating a criminal history evaluation tool for employment purposes. I'm Mike Coffey, president of Imperative Information Group. Imperative is a background investigations company based in Fort Worth, Texas, and I've been in and around HR for more than 20 years now, and maybe HR credibility isn't the same as street cred, but I've worked with a lot of really smart employers, both HR people, both when I was in HR and in the last 15 years that I've been consulting with HR folks about all kinds of people matters, everything from social media to background checks and employee relations issues. What I do want to say, though, is I'm not a lawyer. And so we're going to talk about a lot of legal stuff today, and I'm not a lawyer. So it means in some things I may not be as conservative as your legal counsel. So you probably do want to go talk to your attorneys before you do anything we suggest here. And if they disagree with me, you can always go get another lawyer, or you can modify the information I give you to suit your purposes wherever you are. We're talking about issues today that are governed by a whole bunch of different laws. You've got Title VII, but you've also got state laws. You've even got city ordinances in some cases. So I want to make sure that everybody understands that I'm not giving you legal advice, but what I'm saying is here's some practical ways that we've helped clients solve some of the issues that we discuss here today. And also, if you have knucklehead managers in your environment, some of the things we talk about today may be things that you want to do in HR, but you don't want to roll out to the entire, all of your hiring authorities, simply because we all know we've got managers who do things sometimes that we don't want them to do. And so you want to make sure whatever you do, you train them well. There are certain things you're going to hear today that are strictly gospel according to Coffey. These are things that come from my experience and suggestions on how to be productive, but again, they're strictly my opinion, and I'll try and point them out, but I think you'll know them when you see them. But they're just, we've got to, in HR, we've got to stay in business, we've got to keep the company in business, we've got to make sure that we're creating a safe and productive workforce, and we've got to, at the same time, make sure that we do our very best to avoid litigation, because that's expensive. Even if we win it, we lose. And so we'll try to do everything we can to avoid getting you sued today. So let's do a poll real quick here. How many of you have a policy covering the use of criminal history information when you're making a hiring decision? So if you'll just make a selection there. Okay, well, let's see here. A little over, about 2/3 of you have voted so far, so I'm going to go ahead and close that. The last of you can jump in there. Oh, people are still doing it, so I'll wait a second. And I could probably make this poll a lot more gradient. Okay, let's go ahead and close that and share those results with you. There you go. So you can see that about half of you have a policy of some sort that outlines your use of criminal history information, and I would bet most of those are pretty nuanced and well thought out. We'll talk about some of those ideas today. A third of you don't have a policy at all, and that's not uncommon. And then 20% of you said, yeah, you sort of have a policy. And to be honest, that's where a lot of employers that I talk to really are. They've got some kind of policy. Maybe it's not in writing. It's kind of just working documents in HR that they kind of go by, and maybe it depends on the hiring manager and their opinions on different issues. So we'll talk today about a variety of things that maybe will be tools that help you be consistent across the organization and have a documented, defensible process that that you can say we've considered business necessity here, and we've thought through what we're doing. Let's move on to the next screen there. Okay, great. So if you've been in my other webinars related to background checks, you've seen this screen, but I think it's always important for us to always go back to the core issue of why do we even run background checks? Why do we care about applicants' criminal history information, whether we ask on the employment application or at a different point in the process or just wait till the background check's done? Why do we care? Well, we care because, first of all, as employers, we have a responsibility to provide a safe and productive work environment. It's got to be a place where our employees can come and do their jobs and feel safe without having to worry about being assaulted or having their purses rifled through when they leave their desk, those kinds of things. We don't want anybody to injure our customers or the public, and we've got a duty to protect the public from both physical injury or financial harm or those kinds of things. And letting the wrong people in the wrong jobs can pose a public threat. And of course, the company has assets as well, and we want to protect our assets. We want to be able to make sure that we're not trusting our company in the hands of people who are going to take advantage of us and cause our shareholders financial harm. And of course, through all of that, anything goes wrong, it's our reputation as a company that takes a real hit, and the trust that people have in our brand can be really damaged by just one employee. And often, if something's in the media, something goes wrong, often nobody remembers, oh well, yeah, that company was found not liable for that particular person's actions. All they remember is that guy who worked for that company did that thing. And 5 years down the road, you're still dealing with reputation issues from a bad act, even if ultimately you didn't have any real financial or any liability for it. And that's the other thing, is I really don't spend a lot of time talking about litigation as far as a reason to make a good hire, because if you've gotten to the point where you're avoiding litigation, the rest of your everything else is gone wrong. And if you're really concerned on making sure you've got a safe, productive workforce, that you're legally compliant, and that you're putting the right people in the right jobs, litigation is not going to be a big concern for you. So if you're doing everything on the front end right, litigation is going to be a smaller concern, we certainly hope. So let's get right into this. A number of you, I know, have already attended our policy considerations to avoid discrimination claims webinar, or seen the presentation at HR Southwest or at your SHRM chapter. But I'm going to cover at a high level view Title VII real quick, because a lot of that Title VII and disparate impact theory impact everything else we do the rest of the process. I don't want to just gloss over it too lightly. So Title VII creates protected classes. And these are people that are protected from discrimination in employment based on their existence in these classes, whether it's race, color, sex, national origin, or religion. The law was signed in 1964 by President Johnson, 50 years ago this summer. And then the last time it was significantly amended with regard to the issues we're talking about today, especially disparate impact, was 1991 by the first President Bush. So the important thing that I want to remind everybody here is this law hasn't changed much. Okay, the last significant court decision we're going to talk about was 1975. So this is a law that hasn't really seen a lot of change, but it's getting a lot of focus now because the emphasis of the regulatory agencies has changed, especially the EEOC. So let's originally Title VII prohibited disparate treatment in the employment context based on being in a protected class. And disparate treatment, we know it when we see it. We're not going to hire women for this job. We're not going to hire African Americans for this job. It's pretty straightforward. We know it when we see it. We don't have when there's no bona fide occupational qualification, we just have preferences sometimes that we're not going to hire people for certain jobs, even if we think we're doing them a service. Like, we're not going to put women in this job because they've got exposure to chemicals that would may affect their ability to have babies or whatever. That is, and the courts have said, that's not a bona fide occupational qualification. That's not a reason you can treat women differently in the workplace. So disparate treatment, we pretty much know it when we see it, and I think it's increasingly rare in the American workplace. Now, disparate impact is a little harder to define. Probably the best way to explain disparate impact is to look at the Griggs v. Duke Power decision, which basically said that in the Griggs case, what had happened was Duke Power had a policy that said in order to become a manager or supervisor, you had to have a high school diploma and pass an intelligence test. Well, they put that policy into place after the Civil Rights Act was passed in 1964, and because they were, in the South, and it was the South 50 years ago, African Americans there were much less likely than the white population to have had access to a high school diploma, the opportunity to pursue an education even, because of this, just the raw discrimination that was going on at that time. And so a group of African-American employees said, well, this isn't fair. We could, but for the fact that, we weren't even given those opportunities to have a high school diploma, we would be able to apply for these jobs. And they argued that having a high school diploma didn't make you a better manager. And in fact, they were able to prove to the Supreme Court that that Duke Power had managers who had been longtime managers who didn't have high school diplomas, and their performance was no worse than those managers who did have high school diplomas. So the high school diploma was not a determining factor in whether someone was a successful manager or not. Therefore, the fact that a large number of people in a protected class, their black employees, did not have diplomas and were prevented from becoming managers or supervisors because of it, created a disparate impact. It created what the Supreme Court called headwinds to people advancing in these positions that weren't related to an actual business reason for it. Even though Duke Power even had a process in place where people could, including their black employees, could pursue a high school diploma or a GED, that still didn't remediate it enough to give the black employees the same opportunity. And so we got this idea of disparate impact. There wasn't anything in the policy itself that said, blacks can't be supervisors. They just had criteria that seemed neutral, but in its impact created a disparate impact on people in a protected class. And so most of what we talk about to the rest of this webinar is going to be disparate impact concerns, where we're always going to be going back to what's the business necessity, what's our business reason for this policy. Are there any other alternatives that we could pursue to get the same outcome that may be have a lesser impact on people in a protected class? So that's what we're really talking about today, disparate impact. That was 1971, and then in 1975, the Green versus Missouri Pacific case came out of the 8th Circuit. Now, in Green versus MOPAC, what had happened is Missouri Pacific Railroad had a policy that was across the board. It's a very broad policy that said, we will not hire anyone with any criminal conviction history, period. So it didn't matter if you were 40 years old and you had a shoplifting conviction when you were 18. It was not an issue. You were not eligible for hire. There was no mediating factor. So this was a complete and total exclusion to employment if you ever had any criminal history. Missouri Pacific thought it was in good shape because it was a policy that was applied equally to everyone, regardless of their age, race, sex, national origin, any of those things. So why would this be illegal? Well, there was a man, Mr. Green, who applied for a job with Missouri Pacific and was excluded from employment because he had a criminal conviction back in, this is in the early 70s, and maybe I think it was 5 or 6 years earlier, he'd been convicted basically of draft dodging, evading the draft. Remember, this is the Vietnam era. And he served federal prison time because he was a draft dodger. And I don't mean to use that term pejoratively, it's just, evading the draft. So he was excluded from employment, although there was no relationship to that offense and the job for which he was being considered. This blanket exclusion really made it, and he happened to be in protected class as well. So this blanket exclusion made it, impossible for him to go to work at Missouri Pacific. So he sues, and the Eighth Circuit agrees with his argument that this broad exclusion, it doesn't have a basis in any real business necessity, is overly broad and is excluding minorities at a higher rate than it is white employees or white applicants, because at that time in much of the United States, African Americans were arrested, prosecuted, and convicted at a higher rate than the general population. So that policy in its effect and its impact was impacting African Americans at a higher rate than the white population. So the court said, first of all, if you're going to consider this criminal history evaluation, it needs to be more nuanced, and it can't be just this broad exclusion. And in the court's decision, they discussed, and it's never is it bullet pointed like you see on the slide here, but they said that among things that employers should consider are the nature of the offense, how long ago it was, and how does it relate to the job? What's the job, and how does that offense relate to it? And I think most employers that I've talked with over my career certainly are considering factors like this. Now, the important thing to know is that in the Green decision, this Eighth Circuit Court did not say these are the only factors employers may consider, because you've got to look at, again, business necessity. So what makes sense for your organization may have other factors in addition to these, and that probably makes perfect sense. And we'll talk about some of those. So, but do remember the nature of the offense, the time that's elapsed, and the nature of the job, because those are going to influence heavily some of the decision-making processes we walk through in the coming slides. Also, if you have questions throughout this process, please feel free to drop them in the question box, and I will answer them at the end of the webinar. But go ahead and drop them in now. It won't hurt my feelings if we answer it later on, but that way you remember them as well. And I'll be sharing the slides with everyone later on this afternoon. Everybody who attended will get the slides and a link to watch the recording of the webinar if you need to share it with somebody. There we go. So what we get out of the Green versus Missouri Pacific decision is that we need to review the whole applicant. We need to look at their criminal history, certainly. But they've also got experience, they've got education, they've got other skills that they bring to the table. And so let's consider this criminal history as part of the whole applicant. And I think that's what most employers are doing, but most of the discussion, either from the EEOC or from groups that advocate for former offenders' rights, and reintegration groups, things like that, a lot of what you hear from them is the belief that most employers are automatically excluding individuals from consideration based on their criminal history without any fair consideration of those factors about the job and the offense, how much time has elapsed, and the rest of everything else the applicant brings to the table. In my experience, that's not been the case. Most employers are looking at the whole applicant, and they're saying, for a qualified applicant, we're not concerned about certain kinds of offenses at all, unless there's several of them and they produce a pattern that makes us question their judgment. But, in general, we're not concerned about, just one or two offenses in their history that aren't related to the job and maybe, have some time between then and the time the applicant's being considered for the job. So and this is really what we want to do. So we're going to talk about tools to help look at the whole applicant today. What you don't want to do is have some sort of criminal records bright line rule like this, where you say a clean background check is required. Maybe that, it's in your job posting or in your job description, those kinds of things. Because what are you saying when you tell an applicant clean background check required? It means no criminal history, right? Nothing negative in your background, and that's just that's the same thing as a bright line rule, as a total exclusion, or no felonies allowed. And sometimes people get kind of worked up when we say no felonies allowed, but in Texas, your third DWI is a felony. So are you really concerned for somebody who's going to drive a desk? They're not going to operate a motor vehicle. They're not going to operate any heavy or dangerous equipment for you. They're just going to sit behind a desk all day. Are you concerned that they got their third DWI 6 years ago and haven't had any other interaction with criminal justice in the meantime? Probably not relevant in most cases. So, but as soon as you say no felonies allowed, you're excluding that individual from consideration. And then no convictions for theft or dishonesty. We've seen this play out with the banks recently, because after all the financial shenanigans of 2008 and 9 and all the reform acts that came through, suddenly federally insured financial institutions had new requirements from their regulating agencies that said they can't have any employees who have convictions for theft or dishonesty. Well, that's great, except how is it even relevant when somebody's been somebody's at 40, 45 years old and their last, their last and only conviction was for shoplifting 20 years ago. That's a conviction for theft, right? But is it really relevant to the job, and or does it really even speak to who this person is today or what they bring to the company? Well, these banking institutions had to terminate some of these employees because the regulators said they had to, and then the employees had to go through these processes where they appealed it to the regulatory agency to try and get an exemption from that requirement. So again, is this offense 15, 20 years ago really reflective of who this person is now and what they bring to the table? Now, if they committed an offense 15 years ago and they spent 12 of the last 15 years in prison for it, then certainly it's something you're going to be interested in. But in a lot of cases, people have gone on and lived productive lives and all of that. Now, we're talking about Title VII concerns and disparate impact concerns here, but let me just talk to you straight from an HR point of view. These kind of policies that we see on the screen here aren't good policies, even if it was legal. Why would you want to exclude otherwise qualified candidates from consideration just because of, a piece of negative information in their background that isn't directly relevant to your consideration? So, arbitrary, requirements. If you're an HR person, you've probably dealt with enough hiring managers over the years who want to put arbitrary requirements in that they think help predict success in the job, but they can't quantify that. It's a preference by that manager. And you've seen it, and they want a college degree for the guy who's going to push a broom, those kinds of things. They're just convinced that they've got the secret to what makes somebody successful in their job. And really, you have to go back and suggest that they, try to find a way to validate that other than just a hunch on their part, so that you don't, exclude a bunch of qualified candidates from employment simply because of an arbitrary requirement. This is the same thing. Why would you want to exclude somebody who's going to be a qualified candidate for you? Because your hiring managers all think you've got a drawer full of qualified applicants just waiting to start tomorrow anyway. So, they think your time to fill a position should be a couple days. And the reality is it's not. You've got to go find those candidates, invest a lot of time in sourcing them and recruiting them. So do we really want to exclude people on the basis of something that isn't going to affect their performance at all? So in April of 2012, the EEOC issued new guidance on the use of criminal history. The previous guidance was released in, I think 89 and 91. They had documents they released concerning this. And then quite honestly, they lost some significant court cases. And they've lost all their court cases on this topic, in fact. But after they lost those earlier cases, they decided, well, we need to go rewrite our guidance to be more specific for employers. And there's some good stuff in the guidance, and I will tell you the guidance is a wonderful primer on disparate impact law. It's got about 55 pages of guidance, I think, and then another 50 pages of footnotes, and it's a very, very interesting document. The problem is in a lot of places the EEOC draws the wrong conclusions from the facts. And they come at all of this with a definite agenda. So we've got a whole webinar on this topic called Policy Considerations to Avoid Discrimination Claims. And we actually did that last month, and it's recorded on our website. You can go look at it, download the slides. It's got a lot of information there. But one of the things that the EEOC really wants employers to do is implement these green factors and have a process where you fairly consider people for employment. Now, they also want you to do something called individualized assessment, where you give applicants the opportunity to explain to you why your policy shouldn't apply to them. So you've got a criminal history policy that says we don't hire people with auto theft convictions to work in our car wash if that conviction was in the last 5 years. It probably makes sense. And so the EEOC says that you should be giving these people an opportunity to explain why your policy shouldn't apply to them. I disagree with the EEOC that that's required under Title VII, but it's and it's strictly their opinion. They're not a regulatory agency that makes rules that you have to follow, but it is expensive if they sue you, and you don't want to be sued. So we've got some, in that policy considerations webinar, we've got some considerations for ways you can implement the individualized assessment process without shutting down your HR office and wasting a lot of time with applicants that just strictly based on their criminal history are not going to be the right fit for that particular job. So go watch that webinar. Also, there's a blog post on the website that you see at the bottom of the screen that covers kind of the history of this document all the way to the point where the Texas Attorney General sued the EEOC, and that case is still going through the courts. But let's get back to the idea of how do we review the total applicant? How do you know what criminal history is really relevant, and where do we look? Where else do we look in the applicant's background to help really understand who we're dealing with? First of all, we all know, it's behavioral event interviewing 101. How might, past behavior predict future behavior? That's what behavioral event interviewing is all about, right? We want to ask questions about things the applicant has done in the workplace in the past, how they responded to certain kinds of circumstance, and then we want to try to extrapolate that information into the future in consideration of how they may operate in our environment. So that on the right is a bomb, and I guess that's a bomb there on the left as well. in both pictures. So, you know, this guy on the left may not be the guy you want driving the forklift with heavy munitions on the front end. So let's do a poll because I'm curious. When do you inquire about applicants' criminal history in your organization? Do you do it on the employment application or at the interview or after the offer or at some other point? Okay, we've got about half of you voted so far. Okay, this is about what I see normally, 65. Let's get it to 70% and we'll close the poll. 66, come on, give me a few more answers, guys. 66, 67, okay. Okay, 70, bam, there we go. Let's close the poll and share these results. So, about half of you said you ask on the employment application, which is common. And if your state allows it, I still recommend that's where you ask. We'll talk about that in just a second. 4% of you said you do it at the interview. And if you're doing it at the interview, my next question would be, do you do it in writing? Or do you just make it one of the standard interview questions and you record what the applicant said? I would suggest that if you're going to do it at the interview, that you have some sort of criminal history questionnaire that you actually provide the applicant and have them complete so that you get it in writing. Because when you get that story verbal, it'll change over time. And believe me, I talked to enough former offenders and probably not so former offenders that you always want to nail them down to a story because that story can change over time. 12% of you say you do it after the interview. Then a whopping third of you say you do it after the offer. And in some places that's required. The state of Hawaii is one place where you cannot inquire about criminal history until after you've made an offer. And the idea behind this, it really is well-intentioned. The idea is that this ensures that you consider the applicant fairly apart from their criminal history. And see, that's the argument, though. The argument is that you should consider these people for positions based solely on their experience and their qualifications for the job. And you should, really, in most cases, the belief is out there, and I disagree with it, but that considering their criminal history isn't in many cases valid. And I would argue that in many cases it is valid, even if it's not directly related to the job. Somebody's poor judgment does suggest that they may have issues operating in your environment. And certainly it doesn't seem fair to those applicants that you deal with who may not have any criminal history, for them not to get any credit in this process for having always done the right thing, or at least being smart enough not to get caught. So we'll talk about that a little bit more, but you do want to make sure that when you're deciding when you do the criminal history inquiry, that you make sure that you are complying with the state and even in some cases municipal ordinances that apply to that inquiry. For instance, the city of San Francisco just banned the box. Employers in San Francisco cannot inquire about criminal history until after an interview. And so, there are increasingly more and more employers are banning the box. That's what this movement is called, banning the box, where you don't ask about criminal history until later in the process. And so, and because some states are banning the box and now some cities are doing it, more and more employers are taking it off their employment application. And it may make sense if you're a multi-state employer and you don't have to keep up with all these different rules. And so you just wait until after the interview in most cases, or in Hawaii after an offer, to make the inquiry, and that may be your best business decision. But for like employers here in Texas where there's not such a limitation, I'm recommending employers keep it on the application, because you get your application document in, you've got a good policy that we're going to talk about writing here in just a few minutes, and you get the application, you say, okay, you know what, this person applied for an outside sales position, but they've got a DWI in the last 2 years, and our policy says that we won't put anybody with a DWI in the last 3 years behind the wheel of a car. But we could consider them for an inside sales position. And so you do that right up front. You've got a policy, they told you on the application, and if they were honest with you on the application, which is always a big if, but if they were honest with you on the application, then you can make that offer to them, say, and talk to them. You have a frank discussion with them about it. And you don't waste your time, you don't waste the hiring manager's time, and you don't waste the applicant's time. And that's the problem with the ban-in-the-box rules, is that you wait till later in the process, and now you've HR has said, here's your candidates, and these all look like great candidates. I want you to interview. Hiring manager takes their time out. Somebody has to take the time to schedule these interviews and coordinate it against calendars and all that. You get the applicant in. Manager interviews this applicant with a couple others, and you finally get to your final candidate, and then you make that inquiry, and oh well, actually he's got an offense that would, according to your policy and your business reasons, may exclude him from consideration. And so now what do we do? We've wasted all this time, we've invested all this time, and we can't hire the person. So there are times where it just doesn't seem to make a lot of sense for the employer. So let's see if I can get this to go. Okay. So having that criminal history inquiry on the employment application, or whenever you give it to the candidate, even if it's later in the process, that's the least expensive integrity test you're ever going to give this person. And if you have a really good criminal history inquiry on your application, there should be no surprises when the background check comes back. And likewise for the rest of the things that are on the employment application, making sure that you've got opportunity for your applicants to give really good termination reasons on the employment application, so they can tell you why they left their last jobs, and then making sure they completed they didn't leave any blanks on the application, they completed everything. That way, when you send it off for the background check, all we're doing is verifying what they've done. The background check should come back, if you've got a good process, background check should come back all the time with no surprises. And the background check should really rarely exclude somebody from employment or cause them not to get have an employment opportunity because they lied on the application. Because if they tell you the truth, the only time they should get in trouble or they should have a problem with the background check is when they lied to you, really. So, but we've created a new webinar called Outside the Box: Developing a Legally Compliant Criminal History Inquiry webinar that's going to come up in June. And so we really get into this ban-in-the-box and how to work it out depending on what state you're working in and what restrictions are in place state by state. And I see several people have asked questions about this stuff, and we will get to all those at the end, I promise. So how do we do this? Now, this is definitely gospel according to Coffey stuff, okay? This is, if we want to have a policy that helps us as a company say, these are the kind of offenses that we're generally concerned about, and it doesn't mean they'll exclude them from consideration as applicants, but we're concerned about these issues for these specific kinds of jobs. This is a policy that would say, yes, this person in this group of jobs, like let's say administrative clerical positions that never drive in the course of employment, okay? So, and maybe they don't have access to accounts. So you've got this kind of broad group of jobs, so you don't have to do it for every single job, secretary level 1, secretary level 2, administrative clerk, working in procurement. You don't have to do it like that. You can look at the risks associated with the job and the kind of exposure associated with the job and have this broad category. And then you can say for certain kind of offenses, yes, they're green lighted. That offense in and of itself will not exclude somebody from consideration for this job. Or maybe they're yellow lighted. It's a corporate review of some sort. We're going to look at the details of the offense, maybe we're going to ask our background screening partner to pull court copies for us, which we do all the time for clients, and then you can actually see what the person was charged with and what the nature of the conduct that they were alleged to have engaged in was. And then there are going to be some that are strictly not eligible for hire. It's going to be a red light. I mean, somebody with a sexual assault background is not going to work in your daycare or maybe probably in your healthcare facility. These are not people that you want working close to vulnerable populations. So there are going to be a few that, no, they're just not eligible for hire. And it should be pretty limited in their application. You don't want a broad exclusion, but you can, the great thing about having a policy like this is that once you get the employment application from the individual or their criminal history inquiry sheet, whatever your format is, you can quickly take the information they provided you and bounce it against your policy, and you will know if what the next step is going to be. And you don't have to wait or make a hiring decision on a case-by-case basis willy-nilly, so that you're ultimately going to be in a position where you're inconsistent. And what does that really look like in practice? A matrix kind of like this, where you may have offenses down one side, and then time periods, 0 to 3 years, 3 to 7, 7+. There's no magic number here. I mean, the idea between the different amounts of years is just strictly the idea that the further you are away from your offenses, the less likely you are to commit new offenses or to recidivate. And so how long is it before someone is unlikely to commit a new offense? Well, it depends on what study you look at. Generally, the studies that are out there suggest that typically at about 10 years or so, the individual is unlikely to commit a new offense. Well, really what it says is after 10 years, the individual, if they've been clean for 10 years, are unlikely to get caught committing a new offense. That's, because that's all this information is based on people, and entering the criminal justice system and having convictions. So it could be that, in fact, that this is strictly go, they're older and wiser, and they may be a little bit exercise a little bit more finesse in their conduct. But 7 to 10 years is generally what most employers tend to consider. But there are going to be some offenses. It doesn't matter how old they are. They're just ineligible to work within a specific environment. So in this example, across the top, you see alcohol consumption and possession offenses. We're not really concerned about those for this job. This person's green lighted, or he's yes across the board, eligible for hire, regardless of how old the offense is, even if it was relatively new. But maybe if he was going to be a bartender in your environment, you might say anybody with alcohol-related offense in the last year is going to be ineligible to be a bartender, or something like that. But then you go down to computer crimes, and you see across the board there with computer crimes, the people are listed as yellow-lighted or C, corporate review. So we say for computer crimes, we're not going to exclude somebody. We want to know what the crime was. Did they, use someone else's password to access the company email system because they couldn't remember their own password, or was it something more, nefarious, where they were actually, hacking into another employer's network? We've got a website called Bad Hire Days. It's full of stories of real people in the with criminal offenses and what they did to employers that hired them. And there's one out there about a guy who's a computer consultant now, but he's hacked into a bunch of different computers, a couple different employers' computer networks, and actually served federal prison time for it. But now people are hiring him as a computer consultant. So, the idea here is that we want to go get court copies, really get the applicant's story, have them write down exactly the details. What were they doing? What was the conduct that they engaged in? And also get a feel for whether they're taking responsibility for, their past actions, or they're making excuses for it. And then you go pull court copies and you can go look at the details and see if that lines up. And if it does, maybe you can live with that offense. Maybe that offense isn't something that would exclude the person from consideration. But then you see auto theft, it's red. And so now they're no across, in the last 7 years, are not eligible. If you've been convicted of auto theft in this example, you're not eligible for hire. And let's say maybe this one is a car salesman, and so somebody, we're not going to put, if you've had an auto theft conviction in the last 7 years, we're not going to put you on the sales lot at our car dealership. And if it's more than 7 years ago, we're going to again look at the circumstances surrounding that offense. So it's pretty straightforward, but how do you get to that point? We'll talk about that in just a bit. So what about non-convictions? So we've been talking primarily about convictions, but what about non-convictions? For instance, deferred adjudication. In most states, deferred adjudication means that you pled guilty or no contest to a criminal offense, and then you serve probation, and at the end of the probation period, the case is dismissed. So it's a straight dismissal, but the individual, the defendant, has accepted responsibility for it. They pled no contest, they pled guilty to the offense. I personally spend most of my life on deferred adjudication because I get it for traffic tickets all the time. And it's like my local cop knows, okay, it's been 6 months, Coffey is off probation, let's give him another ticket. And he just sits there waiting for me to blow past him at an overpass on Interstate 20. So that's deferred adjudication. So you as an employer, and the EEOC has even said, the employer's concern isn't the outcome of the case, it's the likelihood that the person engaged in the conduct that was alleged. And certainly if you've agreed to serve probation, you've pled guilty or no contest to an offense, it's reasonable for an employer to believe that you engaged in that conduct. And so under federal law, there's no restriction on considering non-conviction information, even if the case is dismissed. Another good example of that we see from time to time is we work with some social service organizations that are very concerned about the kind of people they have. They give access to their populations, because they work with a lot of vulnerable people. So on occasion, they'll be doing a background check, and we'll come up with 3 or 4 cases for some sort of domestic violence. And but all the cases are filed, but then they're all dismissed at the request of the complaining witness. And what that really means is, typically in a lot of these situations is they, husband and wife or boyfriend girlfriend get into some sort of argument. He hits her. She calls the police to get her off of him. But then down the road, well, she decides, they're back in love again, and she doesn't want to see him prosecuted. And so she won't cooperate with prosecution and asks that they dismiss the case. When you see a series of those, that might give you pause as an employer if you're going to put this person into work with vulnerable populations, or maybe even in situations where there's a high stress dealing with the public and things like that. So even though those cases were all dismissed at the request of the complaining witness, my suggestion to a client would be, well, let's go and look at the police reports. Let's go see what the allegations were, what information was collected when the person was arrested, and let's get the whole picture. And then you can make an informed decision based on all the facts, not just the fact that they were charged with something, but let's go, if the police officers say, they showed up and the complaining witness had a bloody lip or a bloody nose, and that the individual admitted that he hit her and he said he was sorry for it, then maybe that's enough for you to believe they engaged in that conduct. And in certain situations, you may not want to put that person in a certain environment. But you've got to understand there are state limitations. The state of California will not allow an employer to consider non-conviction information. So if even in California, you could admit responsibility for an offense, serve the probation, and when the probation has been completed, that's a dismissal as far as the court is concerned. The case was dismissed, so you can't consider that as an employer when you're making a hiring decision in California. And there are a number of states that have some sort of limitation like that. So you need to pay attention to those kinds of details when you're writing your policy. The great thing is about what we said earlier about focusing on conduct means that you also don't have to worry about misdemeanors and felonies. Because what's a felony in Texas could be a misdemeanor in Oklahoma. And so, you know, whenever you say, well, we're not going to hire anybody with a felony, or you only ask a criminal history question that only asks about felonies, you may be missing conduct that you're concerned about. And maybe you're, you know, a felony theft from 7 years ago may not be a concern for you, but a misdemeanor theft from within the last year would be a concern. So you've got to realize that from state to state, what's a misdemeanor felony changes. And let's not even talk about the way the legislatures have decided to codify different offenses. Let's just worry about what the person did. Let's talk about the actual conduct that they've engaged in, and then we can make decisions based on that kind of information. So let's talk about pending cases. If you've got an applicant who tells you they've got a pending case, how do you deal with it in your organization? Do you consider them at all? Do you ask them to reapply after the case has been resolved? Or do you look at it like a conviction while it's pending, and then, you know, then revisit it after the conviction, after the case is closed? Or does it just depend on the hiring manager or on the job? How do you review this stuff? And 13% of you said other. Those of you who are saying other, drop down to the question box and just let me know what the other means, because I'm always interested in seeing that. So if you're putting other there, and about a third of you have, so some of you drop down there and let me just see what other means to you. Okay, about 42%, about half of you have, okay, 46% have answered. Let's see if we can get a few more answers in here. Hasn't come up. Okay, well, there's one. Okay, pending cases haven't come up. It depends on the job or what the pending case may involve. Haven't run into the situation. We might hold the position for them if a resolution is forthcoming. That's interesting. Doesn't happen often. Depends on the charge, and hasn't come up. Okay. Well, I'm going to go ahead and close that out. About 60% of us have voted, and share these results with you. So really, it was all over the board. 20% of you said we don't consider them. 20% or so said that we ask them to reapply after the case has been resolved. And I don't know, we didn't get real gradient here. I don't know if that means if you would have been concerned about the offense otherwise, or if that's across the board. While the case is pending, we consider them as convictions. Only about 4% of you said that. 23% of you said it kind of varies according to the hiring manager or the job, or 32% said other, and we talked about some of those other ones there. Okay, so let me hide this and go back to the main screen. Okay, here's my guideline. Here's what I suggest. And again, this is gospel according to Coffey stuff, but I always tell my clients, if you would have been concerned about the offense if it had been a conviction and the case is pending, while the case is still pending, treat it the same way. So basically, if the person is charged with an assault, then, and this is a job where an assault conviction within the last year would have disqualified them from consideration, tell them, based on, this pending case, you're not eligible for hire at this time. Please, once this case is resolved, and if you're not convicted, please immediately reapply with us. We can't hold the position open for 6 months or a year, and often it's longer than that before a case gets resolved. So, we will consider if you're found, if you don't accept responsibility for the offense, we'll consider you for a position in the future. Please reapply. That way, you're not in the position of, first of all, dealing with somebody who, going through all the training and everything, of someone who you may have to let go down the road, either because they're not available for work because they're in jail, or because they, they've now been found responsible for this conduct that would disqualify them from consideration as an employee. Now, again, we have to go back to state requirements, because there are, I think there are just 2 states that prohibit. I'd have to go back and double check, but I think there's 2 states that prohibit employers from considering even pending cases. And so, but this is our way of when we're talking to clients, and it's not exactly a a science, but what I like is that the one thing I don't ever want to have to do is go in and terminate an employee who we've spent all this money training and orienting to the job, and then we find out later, well, now he's got a DWI and he can't be a driver, so we have to terminate him. So those are the kind of issues we want to avoid if we can. Warrants, my guideline is if somebody's got a warrant for their arrest, and I don't care what it is, if it's traffic or whatever else, they're not eligible for hire until they've had that warrant lifted. If nothing else, it's just evidence that they've taken care of their business and that they're managing their business for us before you let them loose. Anytime you're talking about a conspiracy to commit an offense or an attempted offense, just treat it like the intended offense. They were trying to engage in certain conduct, and they were just stopped by the police, or were just not competent at doing it. So, and maybe the only thing you don't want to hire more than you want to hire a criminal is an incompetent criminal. Maybe that goes to their own management and ability to get the job done. So, but no, seriously, conspiracy, attempted, those kinds of things, just the conduct that they were alleged to have engaged in or that they were attempting to engage in, evaluate it that way. And then dismissals. Anytime you see a dismissal that you would have otherwise considered, if they had accepted responsibility, treat it as a corporate review. Go get more information. Why was the case dismissed? Sometimes it was dismissed because they were not actually guilty. They were actually innocent. Or they were, they're found not guilty by the court, or there wasn't enough evidence to proceed. So in those cases, that's not going to, in most cases, eliminate somebody from consideration. But just because it's dismissed doesn't mean you've got the whole story. So I always recommend clients, if the offense would have otherwise caused a problem, then let's go back and just double check why the information was dismissed. And that may mean getting court copies. Your background screening company may not be able to tell you from the index information. And then beyond just looking at offenses individually, even if you're not concerned about a specific kind of offense, if somebody has 2 or 3 of different kinds of offenses over a period of time that you're not concerned about, maybe that tells you something else you need to know about their judgment, their self-management, their behavior. And so you need to have something in your policies that gives you the ability to look at a pattern of behavior and make a hiring decision. And then, like I said, remember that some states have limitations on and some states and even municipalities have limits on what you can consider. So you need to really work with your employment law counsel. Your background screening partner should really be able to tell you where you're working, here are the, wherever you're operating, here are the concerns in your jurisdictions. So how do we get to this idea? We're almost out of time, but I want to go through a couple tools real quick, and I'm going to email them to everybody later on so you'll have them. But how do we develop a matrix like this? Well, I've got a couple tools, or really 3 here. First is what we call a position review checklist, and it's one way to evaluate the risks associated with a particular job. So you have a position title or a job category here, and you say this position has access to what? What kind of information or assets or populations does this position have access to? And then you look at the next section, this position's, what level of supervision does this position work with? Are they very independent? Are they out on the road by themselves all day? Or are they working in an area where they're closely supervised? Additionally, what kind of responsibilities do they have in this position? Do they handle cash? Do they interact with customers? Do they manage people? All these different kinds of things. So you get all these different ideas about what their role is and what their responsibilities are, and it gives you an idea of what their risk is. And then you can take that document and look at this job risk evaluation matrix that we've put together, and you can see for if the person has access to certain kinds of and this is an example, it may be different in your environment, but they have access to certain areas or certain kinds of populations or certain things, or what, it goes back again to the supervision level and those kinds of things. Then you see down the side, you say your organization, we're concerned about crimes against people if somebody has access to any of these kinds of things. Okay, we're not talking about the age of the offense right now, we're just talking about generally we're concerned about these kind of offenses relate to these kind of risks associated with the job. And so you can follow through this history here and this tool here and kind of get an idea about what kind of offense categories would be of concern for you for certain different kinds of jobs, and different jobs are going to have different profiles in your environment. And then finally, you can take that information and transfer it over to a criminal offense matrix. And this would be for a specific position or a category of job, but you can see for, crimes against person type offenses, and they're all listed here. And these are the most common ones. I think we've got 45, 50 different offenses listed on this document. And they're kind of categorized: crimes against persons, financial crimes, property crimes, traffic, then you've got public order crimes and integrity crimes down here. So you've got these different kinds of offense, and what you can do is say, for this particular position, an assault or battery, a domestic violence offense in the last 3 years, then you can go in and put your yes, they're eligible for employment. We're not concerned about that. No, they're not eligible for employment, or it's going to be a corporate review. We're going to look at the whole picture. And so those are the kind of issues you're going to have to evaluate, but then once you have filled all this out, now you've got, for that particular class of job, you've got your guidelines. And as I said earlier, there should be very few that are absolute bars to employment. There should be very few that are no, they're not eligible. But you may have quite a few that are C, where you say, yeah, we want to understand all the context. We're going to do a corporate review, a C review of this information, and make sure we understand the context of the offense and what information the applicant can provide, as well as what can be verified from the court's records. And then there are going to be some yes, where they're eligible, and we're not really concerned about this offense in and of itself. And there will be things that are maybe a no, and if it's happened in the last 3 years, but it's a C if it's more than 3, and if it's more than 7, it may be yes, they're eligible. And you may have different numbers. You may not have 0 to 3 years. You may have 0 to 1 years, 1 to 3 years, 3 to 7 years. You can do this according to what works in your environment and the specific risks. You may have regulatory issues in your environment that you have to pay attention to that have specific time periods on them. So these are tools that are general guidelines, but you want to look at the whole applicant, or look at the whole, the whole environment that you're operating in, and make sure that you've considered these things appropriately. And that, dear readers, is the end of our webinar. We do have next month a webinar on driver qualifications for Department of Transportation covered drivers, and what the background check and employment inquiry responsibilities are for employers there. And then, like I said, in June, we've got this new webinar. It's so new, I've never made the presentation, so you'll be the first. It's outside the box, developing a legally compliant criminal history inquiry. So in other words, how and when do you ask about applicants' criminal history information? Our webinar today was approved for an hour of HRCI credit, and so we'll be emailing all of that out to you this afternoon, along with links to download slides and notes and that information. We'll go through the questions here in just a second, but some of you have to run off. It's 2:04, so maybe you have other meetings, and I want to say thank you to each of you for joining us today. Now I'll go through all the questions. If you have any more questions, you can feel free to drop them down there, and I'll stick around as long as we need to answer your questions, and all the questions will be on the recorded webinar as well, so if you want to come back and hear them later, they'll be there First question, I work for a retirement community in Maryland. The big question that we face is how do we balance the EEOC guidelines with the Maryland regulations that say we have to protect our at-risk elderly residents. For example, our residents are more susceptible to theft because they are always leaving money, jewelry out, and because our employees have unfettered access to these residents' rooms and property. Well, the way you would do that is make the EEOC regulations aren't regulations, first of all. They're guidance. The EEOC doesn't have the ability to write regulations that you have to follow. All they can do is sue you. Now it's expensive. It's expensive when they sue you, and you don't want to get sued. But in your environment, in working with vulnerable populations, and it sounds like you've worked out your business case. These are the concerns. My recommendation would be that you do what you have to do to protect your the populations that you serve, your customer base there, and have good documentation as to why and as why you're doing what you do, and you probably will not have an issue here. And the truth is there are very few, even with the EEOC's activity in this, there are very few people who are getting sued for their use of criminal history. You're a lot more likely to get sued for not following the Fair Credit Reporting Act. Then and there are a lot of class action lawsuits about that. So that's what you really want. I mean, if you're going to focus on one thing to avoid litigation on, let's start with the FCRA. And I've got a whole webinar on the FCRA out on our website that we did earlier this year as well. And you really want to make sure you're compliant there. But if you're concerned about the EEOC, just make sure you've got a good policy that you've documented using maybe the tools we've talked about here, but that you've documented the business reasons for the decisions you're making, and you ought to be, in most cases, you ought to be in pretty good shape. It doesn't mean somebody can't file a complaint with you against the, with the EEOC, and it doesn't mean the EEOC won't sue you. But there's no way to avoid, avoid that kind of situation 100% because, quite honestly, the EEOC has lost some cases that certainly they should have lost, but that they pursued anyway, even when they were pretty clear they weren't going to win the case. And in one case, the court made the EEOC pay the attorney fees and expert fees for the company that they said was discriminating based on criminal history. So I think you're going to see more and more of that as well. Let's go to the next one here. I'm thinking of conducting an offer rescinded audit. Do you have any suggestions or templates to conduct this type of audit? I understand what you're saying. I think if I understand what you're saying is that an offer rescinded audit is to go back and look at the people who we made offers to, then we ran the background check. I assume your process is that you make the offer, then you run the background. And then you want to see how many of those people did we actually rescind offers from, or what's our criminal history, how is criminal history affecting our hiring decisions. That'd be a great process to go through. I don't know that there's specifically any tools out there for it other than just going and seeing what the information is. Things I would look at if I was going to do an audit like that are you work with your background screening partner to get some of this information maybe, but look at where in those cases where we did rescind an offer based on criminal history, did we hire other people with a very similar history? Or, what was the criteria for deciding this person's offer was going to be rescinded while we were going to hire this other person? I'm always concerned about being consistent in those areas where the job significantly different, was the offense time period significantly, what was driving that, and how consistent have we been in how we've applied our policy, whether it's a written policy or just kind of a company culture type policy. So those are the things I would look at, and but I think you want to look at, in addition just to looking at the offers rescinded, look at the people who were allowed in the organization. And to be fair, let's look at their status. Are they in any protected classes? Are we hiring white people with certain offenses, but we're not hiring black people with the same offenses? That would be a big red flag for me if I was the HR guy doing that. Okay, let's see here. In our offer letters, we state that Our offer of employment is contingent upon the candidate's ability to pass references, criminal records, DMV driving records, and credit background checks. Is that wording okay? Yeah, it depends on the state you're in, but yeah, generally I think that that language is fine. The word pass, I don't like the word pass because it's not a pass or fail test. What I would suggest is that you state that that you're going to, this offer is contingent on the outcome of the background check. Information provided on the background check will be reviewed and discussed with the applicant. And because if you made an offer, I think you pretty much need to discuss it with them, and then that decisions will be made based on company policy. But if you've got that's a case where you really want a good criminal history inquiry before you make that offer, so that you've given that applicant every opportunity to tell you all about their criminal history. And I would make sure it was as thorough as possible, so that when the background check comes back, nothing surprises him. There's no surprise for you there. Everything that's on that background check is what the applicant's already told you about, or they lied to you, and now you're rescinding the offer because they lied to you. And that's always, for me, that's a no-starter, a non-starter. If somebody's lied to me on the application, they're gone, and they're not eligible for employment. You lie coming in the door. I've got no faith that down the road, when something goes wrong, that you're not going to lie to me again, or you're not going to have other integrity issues. And that's what I always, treat this whole process like a lie detector test. They complete the employment application, and make sure or their criminal history inquiry, and you catch them, making some material omission or just lying to you about something, then how can you say that you're making a good hiring decision if you continue with the employment process with them? With ban the box regulation, would you recommend to ask this question on the employment application, as a lot of the states are accepting ban the box? Yeah, and I think we covered that, but if you're a multi-state employer, I would say, look at what the burden is going to be to have an employment application that is carved up according to states. But even if whenever you do the inquiry, even if it's on the application or later in the process, there are a bunch of states that have limits even about what you can ask. And so if you're going to do a legal inquiry, criminal history inquiry, you're still going to have some state-by-state exceptions. And so you may end up with a Maryland background check or criminal history inquiry, a California criminal history inquiry, maybe even a San Francisco specific one. So really, I don't know that there's a way to avoid that anymore, except for not asking. And I think that's kind of the objective from some organizations out there, to get employers not to even ask about criminal history anymore. But I think that's a bad idea. But it'd be great for the background screening industry, because send us more background checks that we can eliminate the candidates, and you have to hire go find another candidate and send another background check. That I just think from an HR point of view, it's horrible. It's not bad from a background screening company owner point of view, though. Let's see, go through these. Let's see if there's any questions I haven't answered. Will the webinar be on demand? Yes, yeah, we'll get it up probably later this afternoon. You can go out there and download the slides and notes, as well as watch the recording. One person, I think, when we were talking about pending cases, innocent until proven guilty, that is certainly the standard for the courts, for criminal cases. That is not the standard for employers. For employers, the standard is what's in the best interest of the employer. What makes business, what does business necessity tell us to do? And if somebody's got a pending case and their availability is such that they can come to work, they're not going to be in jail, but they've been charged with this offense. At the very least, if somebody is facing a criminal case and there's a pending case against them, a judge or a magistrate has said there's probable cause to proceed here. And if there's probable cause, then there's probably probable cause for you to say, okay, we'll get copies of the police report, we'll look at the details, but until such time as this case has been resolved, you're not eligible for hire. That's, again, gospel according to Coffey. Those are things that I practice and that I recommend, when we're consulting with clients that we talk about. But I do think that that idea of guilty, innocent until proven guilty, that's a criminal standard, but you're dealing more as an employer with a civil standard. Is it reasonable for you to believe that this person engaged in this conduct? And if they've if there's a case pending against them, at the very least you can say we need employees who are going to be, we know are going to be available on an ongoing basis. And if you're facing this criminal offense for this conduct that already would eliminate you from consideration, then we don't have any, one, we don't have any assurance you're going to be available for the employment in 6 months or a year, and secondly, we don't want to be in a position where we have to terminate somebody down the road because of an offense. But certainly some employers may choose otherwise and choose to ignore a pending case, but I would recommend to our clients that they not do that. And that was the last of the questions. We will try to get everything out to you this afternoon. Watch your junk mail for me, because we send all this information out via Constant Contact, and some of your IT administrators really hate Constant Contact, and so anything that comes through Constant Contact is going to hit your spam filter. So you might watch that. But if by tomorrow morning you haven't received the HRCI information and the links to the slides and the other information we're going to send, then shoot me an email, and we will send it to you directly individually, and make sure you've got all the information that you need. I want to thank everybody for joining us. I hope the webinar, we went a little longer than I'd hoped, but like I said, it was the first time, and I hope it was helpful to you. And when you get this information, you get the tools, if you have any questions, don't hesitate to give me a call. Especially if you're one of our clients, please make sure you give me a call. But even if you're not one of our clients, if I can be of help, don't hesitate to give me a telephone call or shoot me an email. Thanks a lot. I hope you all have a great rest of the week. Bye-bye.